It's a divorce case. It's ending up in front of the Supreme Court, and it could challenge Canada's no-fault divorce rule. Joining us from Vancouver to tell us more about this is the ex-husband's lawyer in this case. It's Lorne MacLean. Lorne, good morning.
Good morning, Seamus. Welcome to the West Coast.
Thank you very much for having me. Wanted to ask you, first of all, what's the crux of this case? Can you spell it out for people, why this is so important?
What makes this case so groundbreaking is the portion of the judgment which indicates that the misconduct by one spouse will justify the refusal of the recipient spouse of spousal support in failing to achieve self-sufficiency.
Okay, so go ahead.
Sorry, Seamus. That's at odds with the changes to the Divorce Act that started back in 1968, which indicated that we would now proceed for divorce on a no-fault basis and that conduct shall not be considered.
Now, when you say misconduct here, what are we talking about?
In our case, back in 1998, 1999, my client had an affair.
Mm-hmm. And this is so adultery, which is not that's not presently taken into consideration?
Adultery is a ground for divorce, but the vast majority of divorces proceed on the basis of a no-fault one-year separation.
Right.
We are talking in the current case of a wife indicating, or an ex-wife indicating, she's unable to return to work some 6 years after the separation, in part because of the emotional devastation she says was caused by my client having an affair.
So your client is saying, I don't have the money to continue these hefty support payments, and therefore I don't want to have to pay any more. But she's saying you have to continue to pay because of he committed adultery, and she's still getting over the trauma of that. Am I following this?
Exactly. And now the adultery issue should not, in our submission, play any part in deciding whether someone receives more or less maintenance. For example, if a wife had had an affair, that would not disentitle her to receiving support if she had suffered economic disadvantage during the marriage or had need. In our case, the adultery occurred many years ago. An initial award was made in the amount of $2,250 when my client was earning roughly $200,000 a year, and the wife was unemployed.
Right.
My client dutifully paid that maintenance until he lost his job about a year and a half ago, and it was only at that point that he asked for some relief. Ms. Luskin had worked throughout the marriage. This was not a traditional marriage where the wife was out of the workforce. She had worked for all but about 2 years of the 21-year marriage. So she had significant skills. She is a very capable woman. And Mr. Luskin said, I've lost my job, and it's time now for you to achieve some self-sufficiency some 6 years after we separated.
So the Divorce Act says that behavior, like let's say adultery in this case, should not be taken into consideration by a judge when considering spousal payments. Is that fair to say? But in this case, the judges did take that into consideration and said, yes, okay, you're still traumatized. Yes, we'll take this into consideration. Yes, he has to maintain the support.
Yes, we went up to the BC Court of Appeal, which was comprised of 3 judges. 2 of the judges indicated, without being real clear on it, they indicated they had some hesitancy. They indicated that they would take it into account in looking at a person not becoming self-sufficient. They took into account the alleged emotional devastation. The 3rd judge indicated that that was not an appropriate test to use, and so we believe now that the Supreme Court of Canada must clarify this because it has significant national impact. Are we going to return to fault? Are we going to increase the emotional and financial cost by trying to prove these allegations?
So, Mr. MacLean, what you're saying is that you're challenging the judgment that was made that says that the Divorce Act, which explicitly says that spousal misconduct should not be considered. You're saying we have to appeal this. Now, what if the Supreme Court of Canada says we're not going to hear you?
Well, that is a real possibility. It is only the rarest of cases that will go up to the Supreme Court of Canada.
Yeah.
We have to show that it's of national import, and we think we can in this case because the legislation states very clearly that spousal misconduct related to marriage shall not be considered. And we've got a sort of a real opening of the floodgates if we do look at conduct, because we're going to return to the bygone days, and it's going to increase the stress and the cost for all spouses who are separating.
I have a feeling that, for so many people out there who are going through or have gone through divorce or are going through spousal support payments, this is very important to them, and they understand everything that we just talked about. Thank you very much, sir. We appreciate you taking the time.
Thank you, Seamus.
Coming up.